Hello, everybody, and welcome to History Bite number 181, dated February 12th, 2021. I'm Walter, your mobile historian and blue-collar scholar. This history/law bite is entitled Brown versus Board of Education of Topeka, 347 U.S. 483, 1954. Now, everybody has heard of the landmark U.S. Supreme Court decision in Brown versus Board of Education. Indeed, it is one of the court's, if not the court's, most important and far-reaching decision in history. The Brown versus Board of Education decision upended, to a significant extent, the separate but equal doctrine first established in the case Plessy versus Ferguson some 60 years earlier. And from the Brown decision, we see American society begin the long yet difficult process of integration of virtually all areas in public life. Brown versus Board of Education was the product of several parents initiating lawsuits in 5 different jurisdictions. A class action suit, essentially, it would ultimately end up being. Cases from Virginia, Washington, D.C., Delaware, South Carolina, and Kansas, of course, hence Topeka. And in all of these cases, with the sole exception of the suit from Delaware, all right, the plaintiffs had met defeat in attempting to enroll their children in all-white, thus segregated, public schools. Indeed, these plaintiffs argued that the segregation of public schools solely on account of race violated the 14th Amendment's Equal Protection Clause as required by the U.S. Constitution. And indeed, they had all pretty much formed the same legal arguments. So, with their defeats, the matter would eventually reach the Supreme Court of the United States, with all the suits consolidated under the headline Brown versus Board of Education of Topeka, even though it contained the suits from several different states as mentioned. So the question presented to the Supreme Court was, did the segregation of public schools exclusively on account of race violate the 14th Amendment's Equal Protection Clause? Brown versus Board of Education of Topeka was originally argued in December of 1952. After the arguments, however, it was very clear that the justices were anything but on the same page with respect to an outcome. For sure, 4 justices outright were willing to strike segregation immediately, entirely, and swiftly. That they were Justices Black, Douglas, Sherman, Minton, and Harold Burton. All right. Next, you had 3 justices who, while they were opposed to segregation, didn't feel the time was right to do it. There was no mandate to do it. They were Chief Justice Fred Vinson, Justice Stan Reed, and Justice Tom Clark. And last but not least, 2 justices, Robert Jackson and Felix Frankfurter, who definitely opposed segregation, questioned whether or not the Supreme Court had the authority to bring it to an end. All right. So, as such, the Brown case would be held over and re-argued the following year in December of 1953. By the time Brown was re-argued at that point, the Supreme Court had a new Chief Justice, who we all know very well as Earl Warren. All right? Earl Warren, completely the opposite of his predecessor. Earl Warren made it clear from the get-go that he was absolutely, positively, adamantly opposed to racial segregation and wanted to strike it immediately and without hesitation. All right? He made it very clear to his fellow justices that the opinion here had to be unanimous, as so that there would not be any legal cannon fodder for segregationists to use. All right? And virtually all the court came around, to this opinion that Warren put out there because, he was pretty on point with that. And even with unanimous opinion, there would still be resistance, as we would see. Now, everybody else agreed with Warren eventually, except Justice Stan Reed, who needed a little more arm twisting. Reed's position is interesting because, he authored quite a few decisions not integrating, but in favor of civil rights plaintiffs in times past, including the landmark decision of Smith versus Allwright 10 years earlier. All right, which is covered in a separate video, by the way. All right, eventually Warren got Reed to go along with the decision to strike segregation. And when the Brown versus Board of Education decision was released on May 17th, 1954, Warren spoke for a unanimous court. Justice Reed is said to have cried while the opinion was being read. All right. So on May 17th, 1954, the court's unanimous opinion ruled, and I quote, that separate facilities were inherently unequal, and that segregation in public schools violated the 14th Amendment's Equal Protection Clause. All right. Warren, in examining the historical context of the 14th Amendment, obviously chose not to pierce the perspectives of those who authored the 14th Amendment, conceding that while some might have viewed the amendment as integrating everything, others might not have. So he dodged that issue and rather focused on the contemporary effects that racial segregation had on children. Okay? Warren made it clear that even if state-sponsored racial segregation had produced some sort of physical equality, which it almost never, ever did, the psychological impact upon black children imposed by segregation would obviously render it unequal, as it instilled in black children a sense of inferiority, a stigma, a status of second-class citizenship, something that would be permanent and was not likely to ever be undone. All right. Warren defended his position with numerous psychological studies. All right, most notably by doctors Kenneth and Mamie Clark, all right, who had performed numerous psychological evaluations on black children and the effects that racial segregation had. For sure, the opinion was forceful, and it made clear, based on these studies, of the irreparable damage that racial segregation had upon black children, and how segregation therefore rendered them into a state of inequality, a state that they would effectively never emerge from. All right. Segregation was therefore unequal. And Warren's opinion concluded with the very famous statement that we conclude in the field of public education, the doctrine of separate but equal has no place. All right. Separate educational facilities are inherently unequal. All right. And that, folks, is the gist of the Brown opinion. Warren's opinion in Brown is not very long. Okay, he made it, tightened it up very well, made it, sharp and to the point, emphasizing, over time, the advancements that African Americans have made in spite of numerous obstacles in every way, shape, and form, and how much the field of education has evolved since the 14th Amendment was adopted, up until that point, obviously. Okay? That is how he began his opinion and then moved it to focus on, how segregation in the present context affected black children. All right? Further defended, obviously, by the conditions that black students face versus white students, which are obviously unequal, and then further reinforced by the psychological damage that segregation imposed upon black children. All right. And so that concluded the Brown opinion. Right. Implementation and enforcement of the decision was to be done via the Supreme Court's opinion in Brown versus Board of Education 2, often known as Brown 2, which would be heard and decided the following year. From this opinion, Warren had the matter re-argued to discuss how the decision would be implemented. So that is Brown versus Board of Education of Topeka. Now, of course, as you would expect, this decision was met with almost militant resistance in many areas of the southern United States. All right. In the North, the decision was viewed overwhelmingly favorably. In the Midwest and in the West, hills and valleys. Certain people approved, certain people didn't. All right. African Americans, of course, embraced the Brown decision. It was, like I said, for African Americans, one of the best decisions, if not the best decision, the Supreme Court has ever handed down. All right. with the Supreme Court's mandate, integration still moved very slowly. All right. As a matter of fact, almost 20 years after Brown, you still had jurisdictions who were resisting full compliance. All right. So it's not like this decision was handed down and bam, everything was integrated overnight. Of course, like I said, Brown versus Board of Education was the landmark case which opened the door for the full integration of American life. All right. And after Brown, we see numerous decisions all in favor of integration, as well as the Civil Rights Act of 1964, the Voting Rights Act of 1965, and the full paths of legal equality in the United States for all citizens, regardless of race. Interestingly enough, something that most people don't know about Brown, of course, is that the Justice Department filed amicus curiae briefs in favor of the plaintiffs here, holding that, they urged the court to strike down the segregation laws because of the very damaging image that segregation had upon the United States abroad. In other words, segregation was making us look bad. We were looking like hypocrites, which we were, all right? Soviet Union and other international opponents were obviously making a great issue of this subject, as America's pretending to be the land where everybody's equal, yet you're treating a great percentage of your population like second and third class citizens. So the Justice Department urged the court to strike down segregation so that we can no longer look like a fool in the eyes of the world, like a hypocritical, totally untrustworthy power. All right. So it's just something I'd like to add. And of course, this case was argued by the legendary Thurgood Marshall, one of a couple of attorneys who argued this case on behalf of the NAACP. All right. And with that being said, of course, Marshall would, of course, go on to become the court's first African-American justice in 1967. So any questions or controversies about Brown versus Board of Education of Topeka, leave them down below and I'll be happy to answer them. This is a very heavy case. There are many things which, for the sake of this video, I was not able to include, but from the video, I give you the general gist of the decision. So again, any questions or controversies, please leave them down below and I'll be happy to answer them. All right. If you have not subscribed to my YouTube channel, please do so right now. Just hit that little red subscribe button and that little bell and we will be in business. All right. Take care. Stay safe out there and I'll talk to you at the next bite. Peace.